Howdy and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Andrea Posey, a partner at Cooper's, we will be discussing getting the most out of mandatory settlement conferences. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals, trial, co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Welcome back to the show, Andrea.
Thank you. It's nice to be back.
Today, we're talking about mandatory settlement conferences, and I know that it varies from county to county. Some have returned to in-person, some are Zoom, some are farmed out to volunteer attorneys, some are still done by judges. The MSC is a very interesting experience, and it also oftentimes is an interesting timing for a case because most cases go through mediation and other pieces. And I think that some people view the MSC as they look at the first word, mandatory, as opposed to the next two in terms of settlement conference. With that as backdrop, how have you approached mandatory settlement conferences in the cases that you've been handling, given where they fall in the duration of the case?
I like mandatory settlement conferences. And like you said, everyone's kind of scared at first, especially the clients. It's not mandatory in the sense that we have to settle. It's mandatory in the sense that we have to attend and participate in it. It's a great tool for the timing of it. It's great, especially if it is before expert depositions, because if you can settle the case before you get into expert depositions, you save all of those costs. Sometimes it lands closer to trial and you've gotten into some expert depositions, which may also be great timing because if some of those are going in your favor, it just puts more pressure on them. But settlement conference can sometimes be kind of the last stop before you really are heading into trial. You're preparing the whole time for trial with the case, but it may be the time when the defense really starts to realize, we need to either resolve this case or really prepare for trial. And you may not settle on the day of the mandatory settlement conference. It may happen at some point thereafter up to trial. But I think it's great because you're further along in the case. Each side knows where the other side is coming from, and it's more of a real conversation about settlement than sometimes if you have a mediation early on and there hasn't been a whole lot of progress in the case up to that point.
Before we get to the MSC itself, I want to ask some questions about some of the block and tackle, the minutia, the less interesting, quite frankly, pieces. Does one just take the mediation brief and slap it on pleading paper and submit it as the MSC document? Or are there local rules that one needs to be worried about in terms of making sure that you IDOT and T-cross county by county in terms of the last offer, the last demand, other things that might be nuanced?
Yes. Always check the local rules. And then also look up if you know who your settlement conference officer is going to be. Sometimes you don't find out and you need to submit your brief earlier, but I would look up the local rules. If you do know whether you're going to have a judge or a settlement conference officer, look up that person and see if there's any specifics that they have so you can make sure to tailor it accordingly. The mandatory settlement conference statement may only be due 5 court days or 7 court days ahead of time, but you want to get your brief done well in advance. And the benefit of that is because it's going to the other side. So while the judge or settlement conference officer may not look at it until shortly before, you want to make sure you get it to the other side with plenty of time. That way, the decision makers on the case have all the information they need. They come into it with the authority they need. It's mainly for the other side to be ready to have a meaningful discussion when you get to the settlement.
And I know from conversations with different counsel, different carriers, it can depend on the carrier levels of coverage, how long they need to be able to evaluate and make decisions. I've been told sometimes with, say, companies like Lloyd's of London or multi-layer pieces that it can be up to 8 weeks in advance for very sophisticated layers to be able to make decisions about how much they're going to be putting on the file for the negotiation. Do you have conversations with defense counsel about how much time in advance do you need this in order to have the right decision makers involved?
I do. Generally, we shoot for at least a month in advance. 6 weeks is better. In some cases, like you said, they may ask for more time. And, we try to give them as much time as we can. But I would say to be safe, shoot for a month in advance.
Okay. So I'm going to throw that back at you. 6 weeks in advance, 4 weeks in advance. Oftentimes before an MSC, there's a lot of expert discovery that's going on. How do you then account for changes between the time that it is originally sent out and say you've destroyed their experts or this other critical piece has come forward? Do you do a supplemental brief or some other piece if that happens?
Yes, do a supplemental brief. It doesn't have to be long, but you want to make sure that you have the most updated information, not only so the other side is aware that you're presenting this to the settlement conference officer, but put it in a nice little package for them. If you have some excerpts from the expert depo, great. Other evidence that you want to have all the information in a nice package before you're heading into the settlement conference.
Now, I know some judges have lots of time and read every tiny little piece. Some judges have less time. Do you ever do something to help judges or settlement conference officers absorb all that information in terms of like an executive summary with bullet points? Or this is where we were at mediation in terms of last positions, whose turn it is, so that that person can be booted up?
Yes. I would say in your settlement conference statement, have a great narrative. Don't give them all of the medical records under the sun. They don't want to go through thousands and thousands of medical records. I would pull out the important pages, certain excerpts you can just extract and put into the statement. I would pertinent information, deposition, testimony, things like that. Make sure they have all the exhibits. Definitely talk about prior negotiations, where we were, where we've been, and put your demand in there. I know sometimes the defense doesn't like to even give us a copy of the briefs, but you want to set expectations going into it and give them all that information in a nice, clean package so it's easy to digest.
As we talk about some of the other nuanced pieces, do you have a preference about whether in-person versus remote when it comes to an MSC?
We've been doing a lot of remote. I always think in person is better. Seeing the whites of the eyes, seeing people in person, meeting the other side briefly if they want to, having the other side meet your client, because sometimes they're a file number or however they index their cases, they're a claim number. But it makes a difference when you realize it's a real person on the other side and they see that person. So I prefer in person, but a lot of the times, especially carriers are out of state, so they will be appearing by Zoom. So it seems like most of the time we're kind of in a hybrid situation.
And the other piece that I've found very interesting is there are some counties where absolutely we're back in person, we're doing everything face to face. That is our preference. And others have gone into it's more efficient for us to do it this way. We're going to be defaulting to Zoom. In fact, we'd prefer if you called your witnesses during trial by Zoom. The whole process has been interesting.
It is. And you're right. It's totally county by county. I mean, sometimes we initially will get a notice from the court and it will say that we're in Zoom and we've planned for that. And then we find out shortly beforehand, we're actually supposed to be there in person because the judge we've been assigned to prefers that. So, be prepared for last minute changes and prepare your client for last minute changes.
When I was starting to get into the nuance piece about in-person versus Zoom, on the nuance for clients, are there things that you do for the in-person ones to help the client be prepared? For some of them, this may be the first time in the case where they're going to be at a courthouse, and short of jury duty, it may be the first time that they've ever been to a courthouse. How do you prepare the client so that they're ready for this experience?
I would start with the basics. Like you said, this is probably the first time in the case, maybe ever, that they have been to a courthouse. And if the case does not resolve, they will be back at the same courthouse for trial. So orient them to where they're going. I mean, even the simplest things, the time you have to be there, the date you have to be there, where you should park, maybe meet them downstairs at the entrance so that they know to go through security, because it can be kind of intimidating when there's a huge line of people, you have, law enforcement everywhere and security. So make sure that they feel comfortable heading into it. And they're probably going to feel the most comfortable with you, with them, because they've been dealing with you through the whole case. Give them all of the logistics, tell them what to expect, who they're going to meet. They always seem kind of concerned about whether the other side is going to be there and whether they're expected to interact with them. whether they're going to be asked a ton of questions as if they're being deposed again. So all of those things you want to address with them so that they feel comfortable and there's no surprises.
And I know this seems silly to add on. If you don't already have your client's mobile number programmed or they have yours, is that something that you do because a courthouse can have more than one entrance?
Yes. I mean, I usually have all my clients' numbers in my phone from the beginning of the case. It's easy to get a hold of them and you want them to feel comfortable to reach out to you. But things inevitably will come up and there will always be snags. I mean, it could be that they're in a line of 200 people who have been called in for jury duty and they're going to be running late and then they're stressed out. So you want to make sure that you do everything possible so that they feel comfortable heading into that.
Once you're in the courthouse and there's the component of dealing with the settlement conference itself, do you take advantage of being in the courthouse to learn other things since the trial itself is typically coming up pretty soon?
Yes. It depends on whether your case has already been assigned to a judge for all purposes and you have the same judge throughout the case who's going to hear your trial. If you do, that is an excellent time to pop into the department, talk to the clerks, figure out not only technology, what's there, what you're going to have to bring, ask them about exhibits, just kind of orient yourself with the courtroom. If it looks like we're actually going to start on the day we're supposed to, or is the court backed up? If you're not and you're waiting to be assigned, that's also a great time to go just kind of hang out in the department and listen to cases that are getting set and if they're actually getting out to trial and what judges are hearing civil cases, because you're going to have to make a quick decision on a 170.6 challenge if it's a judge that you don't want. So listen in, take some notes, do your research on those judges. It's great to kind of sit back, talk to other lawyers if you know them in there to see how things are being run. It's a good way to also educate yourself before heading into trial.
This is peripherally related to MSCs and direct assignment. While a lot of counties have gone to direct assignment in terms of having one judge for all purposes, have you had experiences where a direct assignment judge might say on the day of trial, I've been your direct assignment judge this whole time. However, I've got two cases going on right now, so I've worked it out with Judge Schmidlap, 2 doors down. You're going to be in Judge Schmidlap's department starting next Tuesday.
Yep.
And so your concern about doing your homework on what other judges might be there, whether there may be judges that need to be challenged, is that because even when you're directly assigned, you may not actually be directly assigned?
And that's another benefit of being there in person, because if you find that out, then you can pop over into that department and do some quick homework so you know what you're walking into on the day of trial.
By the time you're getting to the mandatory settlement conference, in terms of settlement movement, mediation has probably already happened. There may be formal offers to compromise that have been issued under 998 from one side, both sides, all sides. As you're going into that negotiation, are you worried about the posture of the case, particularly if you don't want to move off of a formal offer?
Usually by that stage, our 998 is our number that we're going to try the case against. It's a number that we feel confident that we can beat, but it's also high enough that if the other side takes it, we're okay with that. And we can sometimes be stubborn. A lot of the times we will dig our heels in and we will try to not move off of it. Inevitably, the judge will try to get us to come off of it, but sometimes it benefits us to hold the line. Because like I said, even if you don't resolve the case on the day of your mandatory settlement conference, there's always time for more negotiations, even the courthouse steps or after trial starts. A lot of the times we'll hold the line, but the judge will give us some pressure to come off of it.
The line that I have heard, and I haven't heard it in a while, but there used to be the wizard in the tower in one particular county who would do a variant of, I hear you saying that that's the number you're going to try the case against, but I need movement. And let me tell you how this works. This is a presiding judge county, and cases over 3 weeks long don't get favored. And I make reports. I make reports based on how the people in my department work with me. And if you don't move, I'm going to make my report a little bit different. And I suspect that your case may not be called this time or next time, maybe not even the time after that, because it is a longer case. So with that in mind, I'm hoping that I can get you to move from X to X minus 10. Have you had that kind of an experience with a judge?
Yes, we have.
And this comes down to what really happens in an MSC in terms of the sausage making and the pressure that the robe applies that is different than a mediator. How do you politely decline a forced move?
Usually it's a situation where it's probably the other side's move. And most of the time, we won't make a move until they make a big move. But we just remind the judge that we enjoy trying cases. And this is the number that our client wants to be at, and that we're happy to try the case. We try to hold the line as much as possible and respectfully. We really believe in our case. Even if that's all that's communicated to the other side, they know that we're ready to go and that we're prepared and that we're happy to do it. And, that puts a lot of pressure on them.
Oh, but Ms. Posey, you are not from this county. And I have to let you know, jurors from this county, they're hard on non-economic damages. And while you may think that your case has a certain value, I want to tell you that over the last 6 months, there has not been a number like that from any jury. And I suspect that you're going to be sadly disappointed, and so is your client. So I need you to rethink that move. Have you heard that?
I will say we actually just recently heard that on a particularly difficult county, and we ended up with an amazing result. So don't be intimidated by it. If you feel strongly in the case, there's no point in digging your heels in just to dig your heels in. But if you know that you're prepared, you feel confident in the case, your client is risk tolerant and is okay with going to trial because it's not for everybody, and you believe in it, then hold the line. It's worth it.
Are there other tactics that you've seen employed successfully at MSCs, either by yourself or others, that you think are worth bringing forward?
There's a real good benefit to mandatory settlement conferences, and sometimes it may not be in a setting where you have a judge. We've had a successful situation where we had an attorney that was assigned to us who was hoping to build a mediation practice. And that was really beneficial because sometimes when you just have a one-day conference with a retired judge, that may be the end of it. And then you're kind of back to either just negotiating with the other side on your own. But, like I said, we had a benefit of having an attorney who was wanting to start a mediation practice or is in the beginning stages of it. And it was great because he continued to follow the case after that. And we ended up being able to settle the case and get a great settlement while we were trailing for trial. So don't be turned off if it's someone that you've never heard of before and that maybe doesn't have a whole lot of experience in it, because it can be someone who will really do a great job for you and stick with the case. And they're motivated to get the case resolved and have it be a good outcome so that people will talk to other attorneys and use them going forward. So be open to it, be prepared, and make sure that your client's on board every step of the way.
That is a very good point. I think some people make the conclusion that if it is a settlement conference officer, it's some lawyer, like you said, who's trying to build their mediation practice, I'm probably not going to have anybody who's going to be any good. And you learn that those people, because they're so aggressive, sometimes are the most diligent in terms of getting the gaps closed and keeping the pressure on.
Yep. One of the things that we notice all the time, whether it's a mediation or a settlement conference, the other side may not be ready for the big numbers. And it takes them time to process everything that they've heard from the settlement conference officer. It may take time for them to talk to people above them to get the authority. And that sometimes isn't accomplished on the day of the conference. So it's good to have someone that kind of follows up and works toward getting the case resolved if it's possible.
Another tactic that I've seen, and some counties use this more, other counties will be open to the idea if it's brought up. I've seen situations where the defense doesn't show up with the adjuster who's assigned the case. In fact, doesn't even show up with an adjuster. They will sometimes use a third-party administrator or, in essence, a stand-in, a person who has no authority but is there just to jump through the hoop for the MSC. And in those situations, I've seen judges sometimes say, well, the rule says you're supposed to have a person with authority. You don't. I'm going to sanction you $5,000. Now, that sanction will be credited against any settlement that you pay, and we're going to continue this till tomorrow, and I need the person with authority to be here. Have you had that experience?
Not to that extent, but I have seen judges tell the parties to come back and mainly tell the other side to have an adjuster there with full authority. Because the idea is to have everybody there in good faith and try to procure a settlement if possible. And if you have someone there who doesn't have any authority, then it's not going to be productive. So I think that does get back to the judge. It's nice on our side when the settlement conference officer will make that kind of call, because otherwise it's just wasting our time. It's wasting our client's time. And, it doesn't benefit anybody.
One of the reasons I brought that up is because Marin is kind of notorious for using that kind of a tactic. However, if you suggest it in another county, I've seen judges say, "Oh, I haven't heard of that. I like that. In fact, I'll do that here." And that then can accelerate the conversation. I mean, yes, it means you have to come back the next day or the next week, but it puts the other side's feet to the fire and helps them understand that they actually have to do something on this case.
Yep.
One aspect in terms of preparing a client that tends to be very different between a MSC and a mediation is during the mediation, the client is usually a very active participant in the caucuses, meaning the mediator greets the client, engages with the client, may do a second round of this is what to expect during this process, may ask the client if they can show up in a joint caucus and talk to the other side. Most MSCs, particularly the judicially managed ones where you're in person, you're called back into chambers and the client stays out. And of course, the client really wants to know what's going on. How do you handle preparing the client so that this doesn't catch them off guard and so that they feel looped in terms of the process?
Yes, that's a good point. Let them know that that's likely to happen, that sometimes the settlement conference officer will want to speak to just the attorneys. And maybe it's because it's stuff that's sensitive that they don't want to say in front of your client. Maybe it have to do with like a legal strategy or something like that. But let the client know that that's likely to occur. And then afterwards, you will be sure to fill them in on everything. And I think that way they're not caught off guard and they're just kind of left sitting out there wondering what's going on and, feeling uncomfortable.
Also, in terms of decision making, sometimes a client needs someone else involved in the decision making, meaning a spouse, a significant other, someone else who is a trusted partner in their decision making. Do you have a conversation before the MSC to make sure that that person is either going to be there or is going to be accessible? Because there is a very real chance that today may be the day that the case gets settled.
Yes. And I think that's important because they've been through sometimes a couple years of this case going and not a whole lot of movement. And to know that all of a sudden it's done, it's sometimes shocking to clients. So to get them prepared for that and let them know what that looks like if we do reach a settlement, well, what happens after that? And let them know what that process looks like, talk to the people that they want to, make sure that they're comfortable with the numbers that we're going to be discussing, things of that nature, just so that they know what the process is going to be like.
And we breezed past some of the just standard work that needs to be done in advance, just like a mediation, of making sure the client knows the fee percentage, because sometimes those fees shift closer to trial, that the client knows where the costs are. And oftentimes you have to ballpark, particularly if with experts at that point, there's some estimation involved, but you always want to overestimate in terms of where the costs are so that you can start telling the client, okay, they're offering $1 million, but really in your pocket, that's X. And the other piece of that are the liens, where the liens are and where one thinks one is going to be able to negotiate it. I presume that's all the work that you pull together and is so routine that it is why we kind of breeze through it at the beginning.
And you make a good point that they hear certain numbers, but they don't know what exactly that will look like on paper. So sometimes we will put together kind of a distribution report or calculation of what that looks like if we settle at that point. And you're right, a lot of the times we have to calculate costs because it takes time to get all the invoices in. But when they can see it ahead of time before heading into a mediation or a mandatory settlement conference, they have an idea in their mind where they would like the numbers to be. And that's a good conversation to have because expectations are very important. And you want to make sure that when you're negotiating or communicating something to the other side, that you're meeting the client's expectations and hopefully exceeding the client's expectations, and that they know at the end of the day what that number is going to come down to before they agree to a settlement.
We get to the point where the case actually gets resolved. and it gets resolved at the mandatory settlement conference. Do the judges typically want to do something day of in terms of putting that settlement on the record?
I would push for it if you can. I think it's important while everybody's there in that moment, especially if you have the adjuster who has authority to bind the settlement under 4.6, I believe.
You nailed it.
Which is great, because that way, the point of that code is if something goes amiss afterwards, we can go into court and ask the court to enforce that judgment based on the terms of the settlement that each side has agreed to. So yes, you will end up having a formal settlement agreement and release that everybody will sign. Great if you can pull that together the day of. Sometimes that's difficult in person. But at a minimum, if you can get that settlement on the record, great. And some judges will allow you to do it that day. It's difficult, obviously, when you're remote, but I would try to do it if you can.
And I have seen situations where even in a remote circumstance, the judge will make a court reporter available. And even though it's via Zoom, there will be a swearing in and a recording of the settlement on the record.
That would be perfect.
The other piece that has been more challenging as time has gone by is, as almost every county now at this point has removed their court reporters from the civil side, it can be challenging to get a court reporter to put the settlement on the record.
That's true.
Are there other details about an MSC that you think are important for people to know?
I would say one of the biggest challenges we've run into is timing of getting everything to the other side. It can be a heavy lift to pull together all of that information in a nice package for the other side and do it a month or to a month and a half in advance. But I think the more times you go through it, you see the importance of it, because there's nothing worse to getting to that day and the other side just does not have the authority and is not prepared to have a meaningful conversation around the numbers that you're looking. So I think the earlier you can pull that stuff together, even if it means during the case, pulling together medical crons and extracting medical records and starting on it, the better. The more time you can give to the other side, I think, is key.
As always, thank you for being here, Andrea.
Thank you for having me.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on how you have successfully navigated mandatory settlement conferences. Like what you heard? Share us with a colleague and leave us a 5-star review on Apple Podcasts. To all of you doing justice out there, happy hunting.